Sawadee Krap. So today I'll be talking on the legality of online arbitration under Thai Arbitration Act, under New York Convention and UNCITRAL Model Law on International Commercial Arbitration. So since now the world is facing the economic depression due to the pandemic, now every part of the world is now trying to do everything online. But I think before taking such initiative, it's very important to know whether what we're doing is right or not, whether it's legal or not. So based on that, at Thai Arbitration Institute, we had done some research on this, and then to see that whether we can do online arbitration or not as per the international instruments and our national laws. So because now Thai Arbitration Institution is also investing all its resources for online arbitration. So based on this, I'll be just talking on that how these things are laid down in our laws based on this. So you know that for enforcing any rules, regulation, guidelines, orders, circulars, notification, or any other actions of the government authorities, agencies, organizations, or cooperative bodies, the action must be based on rule of law. That's very important. Or laws passed by the parliament, which is implemented through delegated legislation, policies adopted by the respective bodies and agencies. So we have to see the legality of our action within all these means. So now based on this general introduction on this legality of online arbitration, I would like to introduce the initiatives taken by Thai Arbitration Institute in introducing e-arbitration procedures with new services now for our clients, which is to be used as an alternative to offline arbitration for resolving current difficulties of the pandemic, which mandates social distancing, mainly to avoid the spread of disease within the communities. So these things are very important. So that's why we have done some research on this. So after the research, we have come to a conclusion that we are authorized to do that, and that I will explain you subsequently after this presentation. So here, what I'm trying to now present to our clients and parties is that what we have done now. We have come up with new initiatives, new services from our institute to all our clients. Firstly, we have come up with this expedited arbitration. Now since there is no time, we need to save time and cost. And for that, we have introduced this arbitration in small claim disputes. For small claims, we are going to do it faster for our parties. So we have already drafted the rules, and the now rule has been also published in the official gazette, and we are ready, and in fact we are now doing online arbitration. So those people who are interested to take up our services, these are available, and everything will be on the website, and then you can browse it. So on the small claims, if I give you a very small salient features of the small claim dispute. So here under Rule 4, the regulation shall apply to arbitration of disputes in which the total amount of dispute in settlement of claim or counterclaim shall not exceed 2 million baht. If the amount is within 2 million baht, then the parties can take up the advantage of this expedited arbitration procedure, which will not take time. Under Rule 10, parties in dispute can appoint representative for arbitral proceedings with full details of subsequent proceedings. So they can appoint their representatives for the arbitral proceedings, but we need to have full details of these representatives for subsequent proceedings and correspondence. Under Rule 10, the sole arbitrator shall be appointed to adjudicate the dispute under the regulation. The institution shall appoint the sole arbitrator here within 7 days from the date of filing the statement of defense. Once the statement of defense has been filed, then the institute will appoint the sole arbitrator. because here there is no time to constitute 3 arbitrators at the tribunal, but the tribunal will consist of a sole arbitrator which will be appointed within 7 days. Under Rule 12, within 7 days from the date of appointment of the sole arbitrator, issues in the dispute and the time shall be fixed for parties in submitting the documentary evidence and other related facts and issues. So once the sole arbitrators appoint, he or she will not wait, but they will now chart down the due process to be followed immediately. Under Rule 13, the arbitration proceedings shall be completed within 45 days from the date of appointing the sole arbitrator. This is very important because we are going to save time and we are going to save the cost. So within 45 days, it has to be completed. The sole arbitrator shall render arbitration award within 15 days. Within 15 days, the sole arbitrator will have to render the award from the date of submission of documentary evidence, unless the institution extends the time. Unless the institution extends the time, within 15 days from the date of submission of the last documentary evidence, the award has to be passed by the arbitrator. Charges, expenses and arbitrator fees, including payment methods, are all specified in Appendix 1, which you will know later when you browse through our rules. You will know. Under Appendix 1, the costs and expenses are all laid down. Initially, the parties will have to deposit 2,000 Thai baht as security for expenses. The claimant shall deposit security for expenses at the time of filing of the statement of claim. That is very important. And the respondent shall also deposit the same at the date of filing the statement of defense. So this is very crush note that the salient feature of small claim disputes. But everything is exhaustively provided in the rule which you will browse later through our rules. The other new service which we have introduced is class arbitration. This class arbitration is very important, where we consolidate the claims so that people will not waste time and they can save cost. So when there are multiple claims, in fact multiple claims consisting minimum of 3, there has to be 3 parties. The parties will have the right to file a consolidated claim which has same facts and principle of law. It should have same facts and principle of law. If these cases are very similar, they can always club, but minimum party has to be 3. Such shall be based on the assertion made by the claimants or on the arbitration agreement. If they have already arbitration agreement being already signed, or there is a clause, they can follow that to have this consolidation, or they can do through assertion later. A representative from the group shall file a petition for class arbitration proceeding to the institute. So on behalf of everybody, there has to be a representative of the group. Then who should file a petition of class arbitration proceeding to the institute? In the petition, the scope of standing must be distinguished. The scope of standing, why they are doing that, has to be distinguished well. And the group of the claimant shall be stated clearly with contact details. We need to have very clear identification of the groups in detail. A group of claimant must appoint their representative to facilitate the proceedings of the group. So there has to be a representative who will represent and follow up the arbitration. The petition shall be consolidated and considered, and the disputing party shall be deemed as one entity. Though there are many parties, so they will be deemed only as one entity. The institute shall authorize representatives to facilitate the proceedings of the group. The petition for joining the group during the proceeding shall be allowed after the consent is given by the members, and that the petitioner accepts the appointed arbitrator and proceedings that is in progress. So the group which is already existing, if any group wants to join, you must get the group who has already initiated, and the person who joins should also accept the arbitrator who has already been appointed, and they should also join the group through the proceedings of the arbitration. In the petition, the scope of standing must be distinguished, and the group of claimant must be stated along with contact details, telephone number, email address for delivering e-documents. For proper correspondence, the details of the group, the details of the representative must be provided well, so that the so that the proceedings will go smoothly. So these are two new services which we are introducing, and it is we have been following. It has been already on the implementation. So we would like to request our clients to take advantage of these new services to save time and cost. So now after that, now I want to give the legality of our action. Are we allowed to do that as per the law or as per the international convention? So therefore I want to say that before implementing the online rules, it is important to determine whether Thai Arbitration Institution is empowered to adopt online arbitration procedures under Thai Arbitration Act. So firstly, I want to introduce under Thai Arbitration Act so that you all become confident on our services, on the legality of the matter. So on reviewing the provision of Thai Arbitration Act on e-arbitration matters, particularly on this, it has been established that the institution is empowered to adopt such rules. For example, under section 6, para 2, which is provided as follows, where a provision of this act stipulates that any fact shall be or may be agreed by the parties or any other way refers to an agreement between the parties, such agreement shall include any arbitration rules referred to in the agreement. So the said provision is broad enough. This is broad enough to cover any arbitration rules or procedures as agreed by the parties in the arbitration agreement or any other rules developed by the Arbitration Institute, who can also include arbitration rules on e-arbitration. So based on this rule, it is so broad that any sort of arbitration agreement is included. So thereby we are authorized to take up this new initiative. Again, under section 7, first para, last line, it provides that unless otherwise agreed by the parties, any written communication sent under this act is deemed to have been received by the addressee if it is delivered to the addressee personally or sent by any other means which provides a record of the attempt to deliver it. This is a particular provision I'm quoting. The said provision further clarifies the intention of the act, in fact, the very intention of the act in providing the flexibility in the arbitration proceedings, wherein the exchange of letters could be in any form, including documents sent through internet or any exchanges conducted through it. So from here also we can always infer that there is a flexibility given by the law. So under section 11 again, second para, it is provided that the arbitration agreement shall be in writing and signed by the parties. An arbitration clause constitutes an agreement if it is contained in an exchange between the parties by means of letter, facsimile, telegram, telex, data interchange or electronic signature. This is very important, or other means which provide a record of agreement. This said provision establishes the very intention of the act to recognize all exchange of letters through electronic means with electronic signature as long as the parties agree and intend to conduct the arbitration through online services. So this is very broad. Telegram, telex, data interchange. These are the salient features of the act, which focuses mainly on the flexibility of the law. Under section 24 again, the arbitral tribunal shall be competent to rule on its own jurisdiction. Such a big power has been given to the arbitral tribunal. So this provision provides again the flexibility of the arbitration, whereby the arbitral tribunal is empowered to determine the jurisdiction of the arbitration. Based on the said section, it can be inferred that fixing the jurisdiction of the arbitrators through online means is also valid. So they can fix the jurisdiction or place of arbitration at any place. So these are the flexibilities given by the law. Then again under section 25, it is given as unless otherwise agreed by the parties or provided by this act, the arbitral tribunal shall have the power to conduct any proceedings in any manner as it deems appropriate. The arbitral award's power shall include the power to determine the admissibility and weight of the evidence. So based on overall intention of the Act, it can be established that the phrase any proceeding in any manner is very important as it deems appropriate. See the flexibility of the said section of the Act empowers the arbitral tribunal to use any flexible means including e-arbitration. So these are the broad powers which are already enshrined under our Act, which authorizes us to take this new initiative for our clients. Then again there is another section which is very important, section 26. It provides as the parties are free to agree on the place of arbitration. Failing such agreement, the place of arbitration shall be determined by arbitral tribunal again, having regard to the circumstances of the case, including the convenience of the parties. See the flexibility. So from the very intention of this Act, it established that the parties are free to choose any place of arbitration, including virtual arbitration. Any place could include virtual arbitration. There is online arbitration or e-arbitration. And that when the parties fail to agree on the place, the arbitral tribunals are empowered again to decide on it, which shall be based on the circumstances of the case or convenience of the party. Just now the inconvenience is that we cannot meet in person. So now we can meet in virtual ways of doing things. And section 26 also gives certain power, which says that the arbitral tribunal may, unless otherwise agreed by the parties, meet at any place it considers appropriate for consultation among its members, hearing of witnesses, including expert witnesses or parties, for inspection of materials, place or documents. When interpreting the said section, again in line with the provision of section 11 of the Act, established that the parties can meet and consult at any place for arbitration, including virtual hearing of the case. This also gives the flexibility. And lastly, the chapter 5 under section 37, second last paragraph says that the award shall state the date and place of arbitration in accordance with section 26 of para 1. Award shall be deemed to make at the place. The said provision refers to section 26 of the Act. It's referring to 26, which provides again the flexibility to the parties and the arbitral award to choose any place of arbitration, including it, which means that we can infer that it also includes virtual arbitration. Now these are the various provisions which are enshrined in our Thai Arbitration Act, which empowers us to take action. Now internationally, whether we are empowered or not. So since Thailand is part of the New York Convention, so under New York Convention also there are a lot of flexibilities given already. So in considering the validity on online arbitration, including fixing the seat of arbitration, it is important to note that as per now, Convention on Recognition of Enforcement of Foreign Awards, that is New York Convention, the parties to the dispute are authorized to determine the seat of arbitration beyond any specific local laws. These are very important, and that such power could be given to the arbitrators or institution by the parties. So parties can always authorize the institution and the arbitral tribunal to fix the place of arbitration. Therefore, online arbitration and fixing online seat of arbitration. So place of online arbitration and fixing or online seat of arbitration is not different from the delocalized arbitration in normal arbitration proceeding. In both the cases, the basic question is whether international arbitration may be performed outside any specific local law or on the virtual forum based on the free will of the parties. So these are the differences that which we can infer from here. So now based on international recognition of delocalization of arbitral seat of arbitration under New York Convention, delocalization of arbitral seat of arbitration, it is not necessary, as per this, it is not necessary for the parties to the online arbitration to artificially change themselves to a specific geographical location or on the ground hearing. It's not necessary to be in person, it's not necessary to be on ground, but it could go on virtual forum. So even under New York Convention, it's given very clearly. The current situation of the pandemic, we know that will adapt anyway to the online arbitration system when it is implemented on the ground reality through viable formulated policies and procedures. Now all over the world, in America, in Europe, in Singapore, Hong Kong, Southeast Asia, all over the world, everybody is following up through online arbitration because we are authorized to do that. So, but we need to have formulated policies and procedures. These are very important. Once these things are done, once we implement, naturally the situation will adapt to it. So for easy and practical reasons, it's important to use national legal framework for each country and other legal instruments within the nations, including international legal instruments relating to usage of electronic means. When considering the option for online arbitration or fixing the online state of arbitration, so we can use our national laws, rules, regulations, international instruments, all this we can use, and within the means of these legal instruments, we can always frame policies to give flexibility to the parties. And under New York Convention, one of the requirement is formal requirement of written arbitration agreement. So is it really necessary as per the provision? This is what I want to just submit. It is important to determine whether online arbitration agreement is valid or not. Whether the agreement signed through online arbitration is valid or not. As per the Convention on Recognition and Enforcement of Foreign Arbitral Awards or New York Convention. Let's say under New York Convention whether online arbitration agreement is valid or not. The Convention, when referring to the Convention provides the flexibility under Article 2.2 by providing that, this is the particular provision, I've just given the extract only. Agreement in writing can be an arbitration clause in a contract or an arbitration agreement signed through exchange of letters or telegram. So agreement in writing shall include even like exchange of letters or telegrams. Although the modern technology and internet was not prevalent at that time, way back in 1958, but the main objective of the framework of the international arbitration was to recognize flexible means of arbitration, which directly correlates to the most recent development in the area of long-distance communication. So it corresponds, the flexibility, the intention of the New York Convention and what we are doing now, it's all in the same, it focuses on one area, that is the flexibility. Therefore, despite the engagement of latest technology in the international arbitration, the backbone of the flexibility of arbitration remains the same. Ultimately, it is the flexibility. So in the light of the said argument that whatever I have mentioned above, it's important to note what Hills has said on this matter, particularly on this matter, what he has said. He said that when reviewing this provision through liberal interpretation, it leads to the acceptance of email-based arbitration. This is because of the similarity between telegram and email. Telegram and email, they are very similar. Therefore, liberal interpretation would be fully in line with the original intent of the drafters. So now, at this period of time, we must give a liberal interpretation of the national laws and international instruments. So this is under New York Convention, which is the overarching law, even which also encourages to give flexibility. And now I would like to focus a little bit on Uncidental Model Law on International Commercial Arbitration, 1985. So under Uncidental Model Law on International Commercial Arbitration, 1985 provides, which provides further flexibility. It also gives further flexibility under Article 7.4, which sufficiently and widely includes even other means of communication has been included there, other means of communication, as long as it provides a record of the agreement. So these are the flexible provisions which are laid down under Uncidental Model Law. So Uncidental Model Law of 2006 carried out major changes on Article 7. Article 7 has been reviewed in a very broad way, and they have done a lot of changes on it, whereby providing that agreement may have been done even orally or by conduct, as far as its content may be identified. So see the flexibility here. If done even orally, as long as we can prove the intent, or by a conduct, if we can prove the intent, even these things are included as a valid agreement. It also further provided that the written form of agreement is fulfilled if the parties use means of electronic communication, and such means enables accessibility to future reference. So here also gives a lot of flexibility, saying that if the parties use means of electronic communication has been honored, has been recognized. So within the means of this law also, we can always infer that we have authority one way or the other. So again, from changes of Article 7 of the model law, it can be deduced that even the written form of agreement is not mandatory under the convention. Therefore, any state which adopts or which has adopted model law of the revised version will not require a specific form of the arbitration agreement. So therefore, the flexibility has been given by all these national law and international instruments. It is also important to note that changes and progress in this field of providing the flexibility was quite intensive, although the basic legal instrument of New York Convention 1958 remained unaltered. Though New York Convention has not been changed very frequently, but still then, now whatever the provision is there within that means has given so much of flexibility to us. So UNCITRAL Secretariat has also taken further initiatives in 2007 by creating UN Convention on the use of electronic communications in international contracts, including online arbitration. So this also gives a lot of flexibilities for online arbitration. So again in 2006, UNCITRAL model adopted a recommendation to provide liberal interpretation of Article 2.2 of New York Convention. So they have initiated this initiative mainly to provide and recognize that the circumstances described therein are not exhaustive, which means that agreement in writing as provided there shall not be limited only to arbitration agreement or clause in the contract signed by both the parties or contained in the exchange of letters or telegram. This is because such interpretation would contradict the very purpose of the convention. Therefore, now from the practical point of view and relevant provisions of various laws, there is no risk of using modern means of communication as far as the means provided sufficient evidence of the will of the possible future disputes. So with this, I would like to broadly say that we have authority, we have taken the initiatives. Now we have also updated our website, and all these laws will be uploaded. Then our software program is also now about to complete, and but we are already doing online arbitrations and all. So we would like to pray all our clients that who has suffered so much to regain from this economic depression. So we should work hand in hand to uplift everybody. We will make everything easy, very smooth, and not only within Thailand but Southeast Asia, even Europe and America, because we are going international. So any part of the world, whoever would like to spend time in Thailand or who would like to use our institution as a means of resolving the issues, we have many highly learned and experienced and good arbitrators on our list. We can take advantage of that, and we are also going to come up with more services. Just now immediately we are using this small claim disputes and this class arbitration, which is very important. So please try to take advantage of, and whatever new development that which we are coming, we will update on and on. please visit our website and take advantage of our institution. We will work hard and we will try to save every one of you to the extent possible. So with this, I would like to end my talk today. I will update later as soon as required. Thank you so much.